Combining the principles that a dying person speaks the truth, free from any motive to lie, with the five golden principles of circumstantial evidence, there is a strong and unassailable case made out against the appellant. And from the discussions as above, the findings recorded by the learned trial court is found to be legal and justified, and the conviction of the accused appellant is confirmed. The appeal stands dismissed.
I agree. Allowed pardon, ma'am. Patila. Already asking. Yes.
Supplementary list for Adjournment, this is related 12 by 2004.
In view of the foregoing discussions, I am of the view that there is no clinching evidence against the appellant relating to her involvement in the crime in question. The circumstances which are appearing on record are not clinching and they do not form a complete chain so as to come to a conclusion with certainty that the appellant is the author of the crime. The findings of the London trial court against the appellant are not justified, and the circumstances which are in favor of the appellant have been ignored, and thereby it has resulted in the miscarriage of justice. Accordingly, the impugned judgment and order of conviction of the appellant under Section 302 of the IPC is not sustainable in the eye of law, and the same is hereby set aside. The appellant is acquitted of the charge. She shall be set at liberty forthwith if her detention is not required in any other case. In the result, JCRLA is allowed. Before parting with the case, I would like to put on record my appreciation to Mr. Biswajit Naik, Land Counsel for the appellant, for rendering his valuable help and assistance towards arriving at the decision above mentioned. This court also appreciates the valuable help and assistance provided by Mr. Rajesh Tripathi, Learning Additional Standing Counsel.
I agree.
Supplemental list. Item number 1.
May I pardon, madam? Madam, this item 1, it is not been communicated by us, madam, today, dear superintendent. So let it be next week, so you can give a, because the jail type of
He was to communicate to whom he wants to engage.
Copy has also been served on you.
my lord.
If copy was also supplied, it was dictated in open court.
My lord, that is our fault, my lord. Sorry, that's
Because that man is supposed to appear.
my lord.
He is now in special jail, Bhubaneswar.
My lord.
So what is
We can pass over, my lord. I will just
right,
intimate.
done.
I
And
can-
council is
yes.
here. We are taking up the moment. Just
Yes, ma'am.
give a
I'll
link,
come. Yes, ma'am.
So, Mr. Mishra, you please wait. He is making arrangements. Okay. Yes.
May
What do you want?
special item 6, my lord.
My policy.
Item number 6.
May I please? I'm
Yes,
sorry,
Lord.
my lord, I'm looked the list, my lord. But in this case, the appellant is convicted under section
You
30.
file an application for bail.
Yes, my lord. Is it 13 years custody and
How many
tribal?
appellants are there in here?
One appellant.
Okay,
Sole appellant.
just a minute. His name is Kanda.
Kanda alias Chandru Hindi.
Acha. Since when he is in custody?
My lord, his custody in 3/2/2011.
And,
13 years.
You have never been released on bail during trial
No, my lord.
and also during pendency of the appeal here.
Yes.
Let me repeat. I will go to. I'll come back to it. Janala Kanda 3/2/2011 ठीक अछि and never been produced in court. Huh? We are in the 9/7 file charge sheet that he is in custody since 3/2/2011 and order sheet indicates he was never released on bail during trial and High Court order sheet also indicates that he was never granted in interim bail. So, what is the offense under which you have been found guilty?
302.
302.
Yes.
What sentence has been imposed?
Yes.
Life
will fine 5,000.
Yes.
What is the name of the deceased?
this is smell, this Sambari Chhattar and his brother, namely
So it's a case of double murder.
double murder. Yes, sir. It's a case of double murder.
Eyewitnesses are there.
Eyewitness, so-called eyewitness is the child eyewitness. He's sleeping another room.
What is the PW?
PW6 man. This child.
He is 14 years.
14 years.
The occurrence is 13.
He is not child. 14 years.
I guess.
So
In the cross
what he has stated that witness about the occurrence.
Para 2 minutes.
Please place that.
I know the accused person standing on the dock, who is Kondu Embram, and he hails from my village. The deceased Uchchava is my maternal uncle, and deceased Sambari is my mother. Occurrence took place about 1 year back in night in my house. I, along with my mother and maternal uncle, were present in the house. The accused person came having armed with tangia and assaulted my mother by means of tangia, which on her head, and she fell down. And thereafter, the accused person dealt tangia blow on my maternal uncle Uchchava, same tangia, and on getting fatal blows, both the deceased fell down and died at the spot. The accused person assaulted my mother by means of a tangia, as he was suspecting my mother practicing witchcraft. The accused person dealt blow to my maternal uncle, as my uncle was present there. After purporting murder, my mother and my maternal uncle, the accused person fled away from my house. On seeing such ghastly incident, I cried and went to the house of the accused person where my father was sitting, and I called father and I narrated the incident before my father. While deposing in the court, the witness is found crying. On the next day morning, police Babu came to my house.
But you know, in the cross-examination, some different part in their my deposition is not clearly visible. So just I am placing my cross-examination. Loading village electricity supply, not electrified. It is just visible only xerox
At about 9:15 p.m.
Yes, sir.
I wanted to go to bed.
Loading in the
On the
village.
date of occurrence night,
Yes.
I was sleeping in our
in
village.
another room. I was sleeping in another room.
Another room.
Just four line. Fourth line.
I was sleeping in another room at a fourth line.
Fourth line, your words.
I was sleeping. In our village, there is electricity supply, and my house is not electrified. On the occurrence night, it was dark. I was sleeping in another room. On the occurrence night, the accused person came, which I had seen. I correctly identified the accused person in my house. On hearing sound, I fled away
to call my
father. On calling my father, I came to my house. I was not examined by police in connection with this case. When defense counsel put question to whom she
has stated about the occurrence, it's not visible.
Witness remained silent without answer. The accused person stared low the head and hand of my maternal uncle by means of It is not a practically no cross-examination is there. Who is the doctor?
Dr. PW 10.
10.
Yes.
He has conducted a PM of both the deceased.
Yes.
Yes.
Uchchava Parida, lacerated wound on the scalp, occipital region, fracture of the occipital bone, hematoma of the occipital region. Opinion, death is due to head injury. Injuries are antemortem in nature. Then Sambari, lacerated wound on the scalp of the so-and-so, fracture of so-and-so, hematoma. So, why this child witness, as you say, why he will be disbelieved when his evidence is getting corroboration from on the doctor's evidence, and two murders were committed in his front. One is his mother, the other is his maternal uncle. So why he will be disbelieved?
Because my lord, the night time is the accused person is another in this village, but the distance area,
What?
distance of the
So you mean to say that crime can be
There-
only committed the
there is no
persons who are
motive.
residing in the vicinity, not the persons who are residing in at a distance place?
so there is no motive also. And
No. When eyewitnesses are there, whether there is motive or no motive,
Motive is there.
that becomes
Suspecting who is
inconsequential. When the eyewitnesses are there,
no,
so if their evidence is acceptable, this child witness evidence. So even if the prosecution fails to prove motive, can that be a ground to disbelieve the prosecution
because
case and
the
pass
eyewitness
an order of acquittal?
no mallet. This
Then
the mallet the statement with the girl mallet. He's sleeping in another room. He's saying the cross examination mallet in the night time.
he has
The
got
occurrence in night time.
night time no ଘଟଣା କେତେବେଳେ ଲାଗେ
9:30.
ରାତିରେ 9ଟା ବେଳେ ପୁରା
Yes, my lord.
ହଉଛି
In the
ଘଟଣାଟା ହେଲା।
that the area is Adivasi area and the jungle area also. You will also know the Doitai area.
କଣ ସେମାନେ ତାପରେ ସବୁ ପୁରା ଅନ୍ଧାର କରିଦେଇ ଅନ୍ଧାରରେ ଶୋଇବେ ନା କଣ କିଛି କିଛି ଲାଇଟ ସୋର୍ସ ରଖିବେନି ଡିବିରି ହଉ କିମ୍ବା ଲାଣ୍ଟର୍ନ ହଉ କିଛି ରଖିବେନି ପୁରା ଅନ୍ଧାର କରିକି ଶୋଇପଡିବ ଆଦିବାସୀ ଏରିଆ ବୋଲି। In our village, there is no electricity supply. My village house is not electrified. The occurrence night is very dark. I am sleeping in another room. On the occurrence night, the accused person seen. I correctly identified the accused persons in the house. On hearing sound, I led away to call my father. On calling my father, I came to my house. I was not sure.
And also, my lord, other witnesses are they are not examined by the police. And also the
ରାତିଟାରେ
164.
ତା ଘରେ ଘଟଣା ହଉଛି ସେଠି ବାହାର ଲୋକ କୋଉଠୁ ଆସିବେ
They
ହଉଛି ଯେତେବେଳେ ସେ ଘରେ ଥିଲା ଏଇ ସମୟରେ ଆକ୍ୟୁଜ ମାନେ ଆସିବେ ଏବଂ ଆସିକିନି ଏମିତି ଘଟଣାଟା କଲେ। They were armed with tangia. First, the assault was made on my mother, and on the head she fell down. Then the assault was made to the maternal uncle, and both of them died at the spot. And it was on account of that the mother is practicing witchcraft. And the father of this boy, Mr. This girl, Buduram Chattar.
yes.
Buduram Chattar has been examined as
PW1.
PW1.
Yes.
What he has stated or he has stated.
I know the informant.
Yes.
I know the informant Budiram Chatar, who is my brother, and the deceased Sambari Chatar, who is the wife of the other deceased Uchab, the brother of the deceased Sambari.
Deceased somebody is my wife.
Yes.
Accused, deceased Ushab is my brother-in-law,
Yes.
being the brother of my wife. Tapare, about 10 months back, occurrence took place. On
Yes.
the date of occurrence in the evening hour, my daughter, Janga Chatar, she is PW 6,
Yes.
went and informed me Allah,
Yes.
that my wife and brother-in-law, were her mother and uncle, are lying in a pool of blood as the accused Chandru Hembram has brutally assaulted them. At that time, I was present in the house. The accused persons, on hearing such, I came to the house. So this conduct is very relevant under Section 6 of the Evidence Act. This girl, after seeing the ghastly murder of her mother, so also her maternal uncle, immediately rushed to her father, informed, and the father has corroborated this one.
He is not eyewitnesses.
Who is not eyewitness?
This person
ये कहला eyewitness दरकार की
Yes.
ସେ ପୁରା ଆଉ ଗୋଟେ ପାର୍ଟରେ ସପୋର୍ଟ କରୁଛି ସେ ସପୋର୍ଟ କରୁଛି ପ୍ରସିକ୍ୟୁସନ ଇଏ କରୁଛନ୍ତି ଯେ ତାକୁ ଆସିକିନି PW6 ସେ ବିଷୟରେ ତା ବାପାକୁ ଦୌଡ଼ିକିନି ଆସିକିନି ବାପା ପାଖରେ ଜଣେଇଲା.
So all the evidences are corroborated to each other. Corroborated, all the evidences.
So
They are not examined by the police. They are
you
first
are going
time
to
they
not
are
examined by ଯେତିକି ଏକ୍ସାମିନ ହେଇଛନ୍ତି ସେତକ କଥା କୁହନ୍ତୁ ଯେ ହେଇନାହାନ୍ତି ଯେ କଣ ଯେତିକ ସେ ଗାଁର ଲୋକ ସମସ୍ତଙ୍କୁ ଏକ୍ସାମିନ କରିଥାନ୍ତି. You want that multiplicity of witness? You mean to say that quantity of witness
no
always
no.
better than quality of witness?
No,
That
no.
is your submission.
The eyewitness the girl, she was not taken the 164 statement before the magistrate matter. Not taken the 164 statement matter.
So what?
Before the magistrate.
So the eyewitness whose version is not recorded, 164 CRPC statement is not recorded, he or she is to be discarded. His version is not to be accepted. That is your submission.
No.
Then 164 statement is not a substantive evidence. Why you are relying upon them when the evidence is there?
Because it's,
you see, that is the discretion of the investigating agency.
Yes.
Unless the prayer is made by the IO, the same cannot be recorded. That is the law.
Yes.
So IO might not have thought it proper
And
that
Malad
to
is
record. So can that be a ground to disbelieve the evidence of this
in
child
custody
witness?
Malad 13 years somewhat.
No, that's all right, but your
in the tribal
paperwork has
person
been
Malad.
prepared.
So at any condition Malad,
It can be added to the hearing list. So there is no problem. 2012 appeal.
yes.
So why? Lekon,
Sub-
are the learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submits that the petitioner is in judicial custody since 3/2/2011, and as such, he has remained in custody for more than 13 years. And the case is based on the eyewitness account of PW6, which is child witness. And since the evidence of the PW6 has got some suspicious feature in it, it cannot be said that she is a truthful witness, and there are good chances of success in the case, in the appeal, and therefore the bail application may be favorably considered. Land counsel for the state, on the other hand, oppose the prayer for bail and argued that PW6 Kumari Janga Chattar, who was aged about 14 years, has stated clearly as to how her mother Sambari Chattar and maternal uncle Uchab what is his name? Uchav Pusti.
Putti.
Purti.
Purti.
Purti died on account of assault made by the petitioner with Itangia. The Learned Council further argued that after seeing the ghastly murder, PW6 rushed to her father and disclosed before him about the occurrence, and PW1 has also supported the same, which is admissible under Section 6 of the Evidence Act. The Learned Council for the state further argued that PW10, the doctor who conducted post-mortem examination of both the deceased, has noticed injury on the vital part of the body, and he has also examined the weapon of offense, that is axe, and opined that the injury sustained by the deceased possible by such weapon. And counsel submits that paper book has already been prepared, and therefore the matter may be added to the hearing list, and it is not a fit case for grant of bail. Considering the submission made by the Learned Council for the respective parties, the nature and gravity of the accusation, the evidence of PW6 as well as PW10, and the manner in which the crime has been committed, we are not inclined to release the petitioner on bail. Accordingly, the bail application stands rejected. However, since the appellant is in judicial custody for more than 30 years, paperwork has already been prepared. The matter be added to the hearing list in the week commencing from 22nd July 2024. Get ready to argue the matter.
Obliged.
The another application is there. Allow the stay realization of fine. Okay. This miss case number so and so interim bill stands rejected. We don't find anything wrong. Yes, next. $57.
Item number 57.
It is that case where he uttered some words.
Yes, my lord.
Making aspersion that this appellant is having a relationship with his daughter-in-law. This is the that was stated by that deceased, that you have kept relationship with my daughter-in-law, and that perhaps was the reason why he was provoked and dealt one blow on the hand.
Yes,
And it was chopped up from the elbow portion.
yes,
Right. So we wanted some decisions on this, that This is the background, and if otherwise the this arch glue coating of that that is corroborated by that doctor, and you produce the court hand in that outpost, right? You are seen going with the court hand, then made extrajudicial confession, then you produce the court hand in the Chorhi whole outpost, and the axe was seized from your position, and that was a Parsuram axe. So place your note, prepared it. Have you handed over a copy to London State Council? Please, please.
My lord wanted to know about some judgment.
No, he has prepared a note. Let us go through. Yes.
On 27/4/2011
Is the date of occurrence.
date of occurrence, my lord.
The same day
On the same
FIR.
day, FIR has been lodged, my lord.
Informant is PW1.
Yes, my lord.
Accused is this.
Yes, my lord.
Arrest was also held on that day.
Same day, my lord.
302 life imprisonment, 10,000 in default to RI for 6 months.
Yes, my lord.
Okay.
Order was passed by the Lord Session Judge.
Come to the para 1, you have stated brief fact.
On 27/4/2011 at about 11:50 p.m. IIC Karanjia received a written report of Vishwambar Naik, PW1, which is forwarded by ASI PW13, Sachidanand Giri, through Constable A.K. Panda, PW12, that while PW1 was at the Kirtan Ghar of their village, accused arrived there with a court hand of the deceased Kunu Naik and told that he is going to police station. Thereafter, PW1 informant went to the house of the Kunu Naik deceased and saw the deceased lying dead with one of his hand cut and removed.
Yes.
Case of the appellant. The appellant has been convicted basing on the circumstantial evidence and extrajudicial confession. That is extrajudicial confession. Report of PW1, 2 and 4. But it is not established. Also, the appellant confessed before PW6.
What not established?
Extrajudicial confession has not been established.
They have not supported the case.
Witnesses have supported.
1, 2, and 4 are the witnesses to the extrajudicial confession.
Yes, madam.
So how you have mentioned that it is not established? In what way?
Not.
আরে রিটিন নোটটা করছেন କିଛି ତ ରିଜିନ ଦେବେ ଯେ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଟା ଏଇ କାରଣ ପାଇଁ ବିଲିଭେବୁଲ ନୁହଁ ଯୋଉ ତିନିଟା ୱିଟନେସ କହୁଛନ୍ତି.
Not what.
Is there any contradiction in their statement, or it doesn't corroborate to the
PW4 to some extent? Not.
ଏଇ ପଏଣ୍ଟ ରେ ସେମାନଙ୍କର ଏଭିଡେନ୍ସ ଯୋଉ 3 ଜଣ ସେମାନେ ସମସ୍ତେ କହୁଛନ୍ତି ତ ଇଏ ଏଇ ଟାଇପ ର ଜିନିଷ କହିଲା. କଣ୍ଟ୍ରାଡିକ୍ସନ କଣ ଆସିଲା, କାହିଁକି ଡିସବିଲିଭ ହବ କିଛି କହିଲେନି, ଖାଲି କହିଲେ ନଟ୍ ଏଷ୍ଟାବ୍ଲିଶ୍ଡ. ଗୋଟେ ସାକ୍ଷୀ ପଢୁନାହାନ୍ତି, PW1 ର ପଢନ୍ତି କଣ? Let us see that. Page 41.
The informant of this case, I know the accused standing inside the dock. I know the deceased. The occurrence took place about 2.5 years back at about 8:30 p.m. At the relevant time, I was present in the Kirtan Ghar of our village. At the relevant time, the accused arrived there with a court hand of the deceased Kunu Naik
and told us that he is going to the police station. Thereafter, we went to the house of Kunu Naik and saw that Kunu was lying on the entrance of his house with a cut injury on his person. That is, one of his hand was cut and removed, and he was dead. I reported the matter at the police station. Executive 1 is the FIR and Executive 1 is my signature. Thereon, cross-examination. I know reading and writing. I have not scribed the FIR. The content of the FIR was not read over and explained to me. The ASI of Chodebhol outpost scribed the FIR in the house of Kunu Naik, and I put my signature. I cannot say who caught and removed the hand of the Kunu Naik, and for what cause, I cannot say the reason as to why Nabar Kishore Naik has been made as an accused.
So he has actually, in fact, not stated that I have got the hand.
Yes, madam.
This extrajudicial confession, he only stated that I am going to the police station.
Yes, my lord.
Okay, and there was a caught hand in the hands of the
Kunu Naik.
accused,
Yes, madam.
right?
Yes.
Caught hand of the deceased, he said.
Yes, madam.
He said
Oh,
caught
you-
hand of the deceased
Oh.
Kunu Naik.
Yes, madam.
How he knew it was caught hand of the deceased, maybe that subsequently found. So let us go to the PW4's evidence.
Yes, madam.
You said that there are 3 witnesses of this type.
Yes.
1, 4, and 1,
1,
2, and
2,
4.
and
So let us come to 2.
PW4, my lord. I know the accused standing in
2 number পর্যন্ত
PW4, my lord.
2টা পর্যন্ত ଆପଣ ଲେଖିଛନ୍ତି ଆର୍ଗୁମେଣ୍ଟ
Yes.
ନୋଟରେ PW1, 2, and 4 are the
Are
3
you-
witnesses.
I know the informant and accused who is standing in the dock. I know the deceased Kunu Naik. Seeing the caught hand of Kunu Naik, PW1 called me. I, along with the PW1, went to the house of Kunu Naik and saw that his dead body is in front of his house without having his left hand, which was already cut and removed. Thereafter, I returned to my house and PW1 reported the incidents to police. The cross-examination by the defense. I have not seen the occurrence. I, along with my wife, mother, and children, stayed in my house. My family members were not present in my house when he asked me to go to the house of Kunu Naik. No other person was present in the house of Kunu Naik when we arrived in his house. It is not a fact that a false case has been filed against the accused Nabar Naik.
Okay, come to PW4.
PW4, my lord.
Hmm.
I know the accused standing in the dock. I know the deceased Kunu Naik. In the year 2011, at about 7:30 p.m., the accused came near Kirtan Mandap with a caught hand and a torchlight. He told us that he had killed the deceased Kunu Naik
This is the 8 hours here. କୁହନ୍ତୁ।
and he is going with the caught hand of Kunu to the Chodebhol outpost. Cross-examination by the defense. Kirtan house was electrified at the relevant time. More than 20 persons were present in the Kirtan house at that time. I do not remember the names of the persons who were present in the Kirtan house at that time. No other person was with Napa when he told us that he has killed Napa and he is going to Chodebhol outpost. In front of Kirtan Mandap, the accused stood on the road. We saw the accused in the electric light, but it was a dark night. The accused is my nephew by village Gorsi. The accused has 3 sons and his wife is alive. The house of Sanmahanta, Mahutia Ho, Dukhya Mahakur, Jogi Giri and others are there in between Kirtan house and the house of Kunu Naik and the house of Kunu Naik. There are about 85 houses in between the house of Kunu Naik and a Kirtan house. I had not gone to the house of Kunu Naik I had also not seen regarding the cutting of his hand. It is not a fact that the accused had not come with the cut hand of the deceased Kunu Naik, and that he had not told before us that he had cut his Kunu Naik hand and that he is going to the outpost. I have no personal knowledge as to how Kunu Naik met his death.
So Kirtan Mandapore, there were about 20 persons,
Yes,
right?
yes,
And it was in the evening hours.
in the evening hour.
So people must be busy in that Kirtan or whatever it may be. And PW1 was also present there.
PW1 was
So PW1 was present there, PW4 was present there.
yes,
And then PW1 called PW2, he came. So only out of the three, PW4 is very specific.
yes.
That this appellant told that he had killed the deceased Kunu Naik and going to the Chadhi Wall outpost.
Yes, ma'am.
Of course, that statement is not corroborated in that way by PW1. But again, it depends upon that who came with his contact, who asked him. But all of them have stated that he was
With a cut hand?
with
Cut
a caught hand
Yes, ma'am.
and going to the outpost.
Ah.
That also stated police station also କହିଛନ୍ତି ଇଏ କହୁଛି outpost. And ଏଇଟାକୁ corroborate କରୁଛି ଆପଣଙ୍କର next circumstance ହଉଛି ଯେ ଏମାନେ immediately ଆସି verify କଲେ
Yes.
Yes, ma'am.
ଯେ ତାର ହାତ ନାହିଁ ଏବଂ ସେ ପଡିଛି। ତାର corroboration ଆସୁଛି ସିଏ ନେଇକିନି କଟା ହାତଟାକୁ produce କରିଛି outpost
Outpost.
ରେ ସେଟା siege ହେଇଛି
Yes.
ଏବଂ ଗୋଟେ ଟାଙ୍ଗିଆ ମଧ୍ୟ right
Yes.
ତା ପାଇଁ seizure list ଅଛି ଏବଂ ସେଇ କଟା ହାତଟା ଯେତେବେଳେ ଯାଇଛି with the dead body
Yes, ma'am.
postmortem examination ପାଇଁ ସେ କହୁଛନ୍ତି ଏ କଟା ହାତଟା ହଉଛି
ସେଇ
ଏଇ ଲୋକଟାର right
Yes, ma'am.
ତାର ମାପିଛନ୍ତି
29 inches.
circumference କେତେ କଣ ଏସବୁ ଜିନିଷ ଏବଂ ଏଇ ଲୋକଟାର ଏଇ ହାତଟା ଏବଂ ଦ୍ୱିତୀୟ କଥା ହଉଛି ହାତ କଟିବା ଯୋଗୁ excessive bleeding ହେଇ ତାର death ହେଇଛି ବୋଲି ସେ evidence ଆସୁଛି।
Yes.
So what how do you mention that this is not established extrajudicial confession, let us say through PW4 also. 1, 2, it's a different matter, but how do you say that how now so far as extrajudicial confession before PW4 was specifically stated that he told us that he had killed the deceased Kunu Naik and is going with the caught hand of Kunu to the Chadheibol house. How do you say that no, it should not be believed? What is the reason?
He had in paragraph 4, he had stated that I had not gone to the house of Kunu Naik. I had also not seen regarding the cutting of his hand.
Cutting the key
Cutting ତ କେହି ଦେଖିନାହାନ୍ତି
Yes, ma'am.
କଟିଂ ତ କେହି ଦେଖିନାହାନ୍ତି ଅନ୍ୟମାନେ ଯାଇଛନ୍ତି ତା ଘରକୁ 1, 2 ଯାଇଛନ୍ତି କିନ୍ତୁ ଏ ଲୋକଟା ଯାଇନି କିନ୍ତୁ ଏ ଲୋକଟା ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ବିଷୟରେ କହୁଛି ଏଠି ତ ଡାଇରେକ୍ଟ ଆଇ ୱିଟନେସ୍ ନାହିଁ It's a case where there is no eyewitness. Case is based on circumstantial
Yes, ma'am.
and the circumstances are the same going with a court hand,
Yes, ma'am.
made extrajudicial confession, produced the court hand in the outpost, also the weapon of offense which was seized. Doctor's case is that also that it is possible and the that tallies that court hand also tallies with the body. So all these things are there. So what other point you have raised in your argument note?
Then the statement of PW6, my lord.
PW?
6. The outpost, he admit before the police constable that out of anger, he has cut the hand off.
That we are stating that perhaps the deceased uttered some words that you have kept a relationship with my daughter-in-law.
Yes, my lord.
But the daughter-in-law has been examined as
PW5, my lord.
PW5.
Yes, my lord.
They stated that after the death of her husband, she was staying
with
in
her
her father's place
Yes, my lord.
and only coming once in a month, perhaps,
Yes.
to collect the pension amount. That is her evidence.
Yes.
So nobody has stated that there was any kind of physical or any kind of relationship between the accused
And
the
daughter-in-law of the deceased.
PW5, right?
Yes, sir.
But perhaps that deceased was suspecting something,
Yes.
and he on that particular day uh, made aspersion that you have kept relationship with my daughter-in-law, and that might have provoked the
Yes.
that is your submission.
Yes.
And it's a case of giving a blow on the left hand,
Yes, sir.
which was amputed and that resulted in excessive bleeding, which caused the death. So these citations which you have given in your note, what does it say? First, you have relied on, Daubha, Ram, so and so. Which paragraph you have not given? Is it a case where the hand was cut?
No, my lord.
Then
Yes, sir. Grave and provocation.
grave and provocation, amore etiju.
Intensity with which the injury has been caused, because it is severance of the hand, decapping of the hand. Had it been a simple blow out of provocation, things would have been different. Here it has completely been severe.
Have you found any decision exactly that somebody's hand has been cut and due to excessive bleeding, there is?
Exact that type of judgment I have not collected.
Have you got the any
I have
decision?
got for judgment, my lord,
Yeah.
regarding the sudden provocation, single blow,
Hmm.
regarding that, and not in the vital part also, my lord. The severe bleeding is that what you're asking. So may I place that some judgment?
No. Have you find out any decision on amputation of hand?
Not exactly on application. Fine.
Actually, you put a research system. এটা চাললি না এন্টার টেস্ট चालू कौन है dead body project is open number for the amputation of the left hand and the amputation of the south. So these are data investigation. Then Christians will and counsel for the appellant raise the issue of funds not amounting to the response to section 1 reduction of sentence. Many distance you have searched for. I've told you that amputation. What you were doing yesterday? Huh? Not, you see, there are a number of decisions are there on amputation of hand, leg, and I'm sorry to say that
direct matters are there. Varieties of cases of amputation.
Every High Court amputation of hand, death, and the conviction has been altered. And here there is a background of provocation also, as it appears.
That provision.
So provocation is there, single blow suppose is there, hand has been cut, excessive bleeding. We wanted you to search for the decision.
I have some decision made, particular not in amputation, but
ମୁଁ ଆପଣଙ୍କୁ କହିଲି କ'ଣ ଯେ ଆପଣ
Single
you
blow
search
and-
for the same amputation of hand,
amputation.
death, single blow ଏଗୁଡାକ ଆପଣ ଆସିଲେ
I have that.
ଗୁଡାଏ decision ଅଛି ଆପଣଙ୍କର ବିଭିନ୍ନ High Court ର. It's not
Yes.
that we are
No, I have on the Supreme Court decision matter. The guideline is
may
fixed
not
on
be of the Honorable Supreme Court, but there are other Allahabad. We are seeing this decisions.
So for
Allahabad, Bombay,
the recent
everything is
decision
there.
matter, 2022 matter, the guidelines are fixed regarding the sudden provocation and the that is measured in Daubaram Nilmakar, state of Chhattisgarh matter. And also that is in single blow matter in 2018 matter, also in Kasi Prasad matter.
So, grave provocation principle has been elaborately mentioned in K.M. Nanavati, which has been followed.
K.M. Nanavati.
That is the locus classicus,
no.
you can say.
You see, there cannot be any
Straight
straitjacket
yes.
formula. You know, somebody, as we are telling, somebody might be provoked in those areas also by little thing. बहुत छोट छोट जिनस ପାଇଁ ସେମାନେ ହାଣି ଦିଅନ୍ତି ଇଏ କରନ୍ତି ତ ତେଣୁ ସେଇଥି ପାଇଁ ସେଇ ଟାଇପ ଲୋକ ଗୁଡାକ ଇଜିଲି ସେମାନେ provoked ହେଇଯାନ୍ତି.
Most of the village areas in Orissa, they go for this local drink salapa. For that they kill. So it is very important in their house. If you have a salapa tree, it is very valuable. If someone takes away one drink, then he will be killed. So it depends upon the place, circumstance, the background of the family, the community.
And there are also cases, there are reported decisions, even they go with the court head
Yes.
to the police station. So ତେଣୁ here we find that since in view of this extrajudicial confession, that because of this, perhaps this because of these words uttered by the deceased to the appellant, that you have having relationship with my daughter-in-law.
That is the evidence of
that is the evidence PW6.
PWC. No, PWC.
PW6
Yes.
Second page.
Yeah. The accused also disclosed before us that he caught the hand of his uncle Puna Naik as the said Puna Naik told the accused this.
ତେଣୁ ଏଇ ଯୋଉ ୱାର୍ଡସ ଟା ୟୁଜ କଲା ହୁଏତ କାହାକୁ ଅନ୍ୟ କାହାକୁ କହିଥିଲେ ହୁଏତ ସେ ସେତେ ଇଏ କରିନଥାନ୍ତା ବା ଗୋଟେ ଚଟକଣେ ମାରି ଦେଇଥାନ୍ତା କି କଣ ହେଇଥାନ୍ତା ବଟ୍ ସେମାନଙ୍କ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ କୁ ଯାଇକିନି ୟୁ ଆର୍ ଟୁ ଜଜ୍ ଦି କେସ୍ ସେମାନେ କୋଉ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ର ଲୋକ ତାଙ୍କର କୋଉ ଏଜୁକେସନ ସେମାନଙ୍କର ପାୱାର ଅଫ ରିଷ୍ଟ୍ରେଣ୍ଟ ଏଇ ସବୁ ଜିନିଷ ଉପରେ ଡିପେଣ୍ଡ କରୁଛି ତେଣୁ ତାପରେ another feature which is most important, be having a sharp cutting weapon like Tangia with him, he could have easily caught the neck,
Yes.
assaulted on the head, but he has not touched those body parts. He has given a blow to the hand.
That also On that light also the distance there, but I have got that.
So you expect you that since we are again keeping this matter to Tuesday, let us search. Both of you search for distance, and you'll show me those decisions today. Okay, in my table. Adjourn कर दो some मंगलवार.
Yes.
You see, a person's life
Yes.
is in your hand,
Yes.
right?
Yes.
Think in that way. That मोरो टिके preparation रे जदि किसी खिलाफ ही जीवो लोकटाको आजीवन कारादंड हेची सेटा रही जीवो. मु जदि समस्त प्रकार मटेरियल ये करी पारे जदि किसी रिलीफ मिली पारे से लोकटा ऑलरेडी केते वर्ष रहलानी 13 वर्ष रही गलानी. तेणु एई मनोभाव करिकिनी आपणकर जदि पैशन रहिबो जे नाही ये करियो then it's all right, you can get something. But आपण amputation ने total decision पाउन दी whereas आमे एठी देखलु decisions are माने सबु हाई कोर्ट practically decisions अछि. लेखन्तु the learned counsel for the appellant filed the date chart and written note of submission, so also some citations which are taken on record. However, after placing the matter on merit for some time, the 6 for an adjournment till 9th of July 2024 for further argument.
In
this
Dhirendra
matter.
Kumar case, madam.
Huh?
In Dhirendra Kumar case, madam. That the law laid down there regarding the to whether the 302 IPC or the 304 IPC, which are whether it fall in the circumstances of the different developers. They have taken some. Can I just?
Yes, yes, of course.
This court in Dhirendra Kumar versus State of Uttarakhand has laid down the parameter which are to be taken into consideration while deciding the question as to whether a case falls under 302 IPC or section 304 IPC, which are the following. A. The circumstances in which the incident took place. B. The nature of weapon used. C. Whether the weapon was carried or was taken from the spot. Whether the assault was aimed on vital part of the body. The amount of force used. Whether the deceased participated in sudden fight. Whether there was any previous enmity. Whether there was any sudden provocation. Whether the attack was in the heat of passion. And whether the person inflicting the injury took any undue advantage or act in the cruel or unusual manner.
ये जित्ती को कहिले ये केस रे मैक्सिमम जिनसांक फेवर रे अप्लाई
That's it.
जदि हमें सेही जिनस गुडा कंसीडर करी
Consider is coming in.
हां
That's it.
you see गोटे लाइन ता जरे आउ किछि एक्सेप्शन कोन हला से जो लाइट टा कहउछंदी जो 3 4 5 आडू कोन कहले अनड्यू एडवांटेज गोटे
Undue advantage.
हला
Whether the person inflicting the injury took any undue advantage or acted in cruel or unusual manner.
now you see somebody is what we pointed out, somebody is having a weapon like tangia in his hand, okay, and he could have assaulted on any part of the body, okay, but he has given one blow on the hand, not touching the head, not assaulting on the neck or on the swans, single blow on the hand, amputation. Okay, and the second one is the provocation. If it is believed or the statement which he has given in the extrajudicial confession, as my esteemed brother placed out, that ei jinso janaku bohu नारे आलिगत हला ताले provocation हबो कि नाही. अच्छा provocation जदि हबो ताकू केमिति सेमाने रिस्ट्रेंट करी परिबे सेमाने को बैकग्राउंड रो तांगर एजुकेशनल बैकग्राउंड कोन सोशल बैकग्राउंड कोन तेणु सेमाने को टाइप रो रिएक्शन करिवे इट
Well-
डिपेंड्स अपन एगुडा को ऊपर निर्भर को
And then another point, my lord, whether the weapon was carried
हाँ
with him or on the spot he got it.
हाँ
That is
सेतरे तो
it is
एविडेंस ही
it's
नाही
silent.
यातर एविडेंस नाही
silent.
तेणु से आपण अगेन इफ यू गो टू द रूट ऑफ द मैटर
हाँ।
वे तो से जो वर्ड्स गुडा को अटट न करिथिले
हाँ।
ये घटना ही हेई न था हला
Right.
तेणु सी मते रीजन दोजी कोन पाई मु काटी देली हाथ जे मते एइया कहलारु मु
Well,
हाथटा काटी
yes.
तो
May I place another
Suppose.
blessing, my lord. That in this my lord in 2015, my lord, Supreme Court has held that what is a critical for a case to fall under exception 1 to section 300 IPC is that the provocation must not only be grave but sudden as well. It is only where the following ingredients of exception 1 are satisfied that an accused can claim mitigation of the offense committed by him from murder to culpable homicide not amounting to murder. 1. The deceased must have given provocation to the accused. The provocation so given must have been grave. The provocation given by the deceased must have been sudden. The offender, by reason of such grave and sudden provocation, must have been deprived of his power of self-control. Fifth, the offender must have killed the deceased or any other person by mistake or accident during the continuance of the deprivation of the power of self-control. ए केस भी केतोटे जिंस सब
ए लास्ट एठी
लास्ट
एप्लीकेबल
नुहे
नुहे
बट अदर्स में
हां
एंड
तो
आल्सो
लास्ट एमती एथि पई रखी चंदी माने जनको जो कहंतीनी मुंडे रे राग चढ़ी गला तो सेते बेले जणे की से गोटे बुझीवा को आस्थिले भी से ताकू ये कर दिए हां तेणु
and the provocation, my lord, another just in Holmes versus Director of Public Prosecution, the provocation has been explained as under. The whole doctrine relating to provocation depends on the facts that it causes or may cause a sudden or temporary loss of self-control, whereby malice, which is the formation of an intention to kill or to inflict grievous bodily harm, is negative. Consequently, where the provocation inspire an acquittal intention to kill, actual intention to kill or to inflict grievous bodily harm, the doctrine that provocation may reduce murder to manglus seldom applies. Manslaughter seldom applies.
so that is there in
Yeah,
if you come to those
And my lord is telling about the Kevin Anaboti, that is there also, my lord. That are more Rashtrapati.
no that background is something of course different,
Different.
that's a different
Different
background. Here we are thinking of that was a highly educated person, so here हमें जो background को जाएंगे नहीं केस टा को
Yes,
देखुचु ये केस रो background
Background
होची
is
गोटे tribal
tribal.
background आउ एठी को हमको जाएंगे नहीं केस टा को ये करिया पड़ियो माने से
So, given the principles, we have to analyze the circumstance available here, whether those circumstances fits into the present case
Case or not.
in order to bring the
आपण जो एक्सेप्शन 1 टारे सेटा
Right.
पूरा सेठी कोट कर दी जंती
Right.
एक्सेप्शन 1 टा कहूची कल्पेबल होमिसाइड इज नॉट मर्डर क्लियरली कहला if the offender whilst deprived of the power of self control by grave and sudden provocation create कला से आरो जण ସେଇଥିରେ causes the death of the person who gave the provocation or causes the death of any other person ହେଲା ଠିକ ତା ଦେହକୁ exception କେତେଟା କହିଦେଲା ଯେ ଏଇଗୁଡାକରେ ଇଏ ଲାଗୁ ହବ ନାହିଁ କୋଉଗୁଡାକ ଲାଗୁ ହବ ନାହିଁ that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to the person ହେଲା ତ ନିଜେ ହିଁ accused ତା responsible ଥିବ ହେଲା ତେଣୁ ମନେ କରନ୍ତୁ ଆପଣ let us say you go to a person's house ତାକୁ ଗାଳି କଲେ ସିଏ ଆପଣଙ୍କୁ retaliate କଲା ଆଉ ଗାଳି କଲା ତାପରେ ଆପଣ ତାକୁ ମାରିଲେ ବୋଲେ ସିଏ ମତେ ଗାଳି କଲା ସେଇଥିପାଇଁ ମୁଁ ମାରିଦେଲି ଆରେ you went to his house you created the provocation ହେଲା ତା ସିଏ retaliate କଲା ତେଣୁ ଇଏ ସେମିତି ହେଲେ ବି ଲାଗୁ ହବନି that the provocation is not giving by anything done in obedience to the law ଏଗୁଡାକ ଏଠି applicable ନୁହଁ that the provocation is not given by anything done in lawful exercise eta nue whether the provocation was grave and sudden enough to prevent the offense from amounting to murder is a question of fact tenu if it is a question of fact okay and if whatever available material on record since there is no direct evidence we are basing on the circumstantial evidence and the prosecution is also banking on the extrajudicial confession and
that is the only matter.
ହଁ ସେଇ extrajudicial confession ରେ ଗୋଟେ ଆସୁଛି ଯେ କଣ ପାଇଁ ସେ କଲା କାରଣଟା ତାକୁ ଆମେ ଦେଖିବା ଏବଂ ସାଇଡ ବାଇ ସାଇଡ ରଖିବା ସେ କଣ କରିଛି whether he has exceeded ବା just self control କରି ଗୋଟେ ମାରିକିନି ରହିଯାଇଛି ଚେକ୍ ହେଇଯାଇଛି ହଁ so ଏଇ circumstance ରେ ତାକୁ whether it would be a 302 or it would bring under any of the exception ତେଣୁ admittedly ଆପଣ କିଛି evidence ଆଣୁନାହାନ୍ତି about the previous motive ସେ evidence ତ ନାହିଁ ତାକୁ ମାରିବାର କିଛି previous motive ଏସବୁ ତ ନାହିଁ enmity previous enmity ଏସବୁ ତ କିଛି ନାହିଁ
ଯୋଉଠି ବେଳେ ଆସିଯାଏ cooling period ଗୋଟେ ଥାଏ ଯୋଉ suppose provocation ହେଲା ସେ
ନା ଏଠି cooling ର
ଏଠି ନାହିଁ
react କଲା immediately reaction cooling period ଥିଲେ it's all right
yes ma'am
cooling period ଥିଲେ ଆପଣ କହିବେ cooling time ଥିଲା ତେଣୁ ତା ପରେ ଆସିକିନି well prepared ହେଇକିନି ଆସିକିନି ମାରଲା ତେଣୁ that would not be there ଏଠି ସେ ଜିନିଷ ତାକୁ କହିଲା ବହୁତ ସାଙ୍ଗରେ ତୋର ଇଏ ଅଛି reaction is immediate given that blow and got
there is something silent manner regarding the provocation
ସେଇଆ ପରା କହୁଛି ସେଠି ଆଉ ଗୋଟେ aspect ହଉଛି ଯେହେତୁ ଆଇ ୱିଟନେସ୍ ନାହାନ୍ତି ଆକ୍ଚୁଆଲି ସ୍ପଟ ରେ କଣ ହେଇଥିବ ତେଣୁ ହୁଏତ ଆହୁରି ମାତ୍ରାରେ ଆଗ୍ରାଭେଟ କରିଥିବ ସିଚୁଏସନ ହଁ ବହୁତ ଜିନିଷ ହେଇଥାଇପାରେ
ତାପରେ ଆଣିକି କଟୁରୀ ଆଣିକି ମାରି
ତେଣୁ କଣ ହେଇଥିବ କି ନାହିଁ ଯେତିକି ଅଛି ସେତିକିରୁ ଆମେ ଆସୁଛୁ ଯେ ଇଏ ଏଇ ଜିନିଷ କହିଲା ବୋଲି ସିଏ ଆଇ ୱିଟନେସ୍ ଥିଲେ ତ ତାକୁ ବହୁତ ଭାବରେ ଆସେସମେଣ୍ଟ କରାହେଇ ପାରିଥାନ୍ତା ତେଣୁ ଯେହେତୁ ଆଇ ୱିଟନେସ୍ ନାହାନ୍ତି circumstantial evidence ର କେସ୍ ଏବଂ ଏତିକି ଆସୁଛି ତେଣୁ ତାରି ବେସିସ୍ ରେ ଏବଂ ତାଙ୍କର ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ତାଙ୍କର ସୋସିଆଲ ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ତାଙ୍କର ଏଇ ସବୁକୁ ନେଇକିନି ବିଚାର କରିବାକୁ ପଡିଲା
Two more aspects that you need to see is this particular statement is coming from the constable.
Yes, before the police station
Yes.
also.
So this statement has been made before the police. Number one, that you have to counter. And the other one is that in the accused statement, you have not taken this defense also. But these two aspects has also to be seen while accepting this part. Because once that evidence is accepted, then even if no such plea is taken, no issue.
କନଷ୍ଟେବଲ ପାଖରେ ଯୋଉ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଟା କରିଛି ତାକୁ ଟ୍ରାଏଲ କୋର୍ଟ ୱେଟ ଦେଇନି ବିକଜ ଅଫ ଇଟ ଇଜ ହିଟ୍ ବାଇ 25 it's all right but we are to see the overall thing and
even otherwise going beyond that also we can see what could be the circumstance whether the particular statement that has come from the mouth of the witness could be there. ସେଟା ଆଉ କେହି କୋଉଠି ବି କହୁନାହାନ୍ତି।
ଆଉ କିଛି ନାହିଁ।
କାହିଁ ଯୋଉଟା ଯିଏ କହିଲେ ବି ସେଗୁଡାକ confront it was not stated before once in the 161. The daughters have stated, but that has not been. This is daughter mane କହିଲେ at release
It will
that
take-
was
says
not
that-
substantiated.
It is not.
Because
not
that is not so. କାରଣ ତା ନିଜ ଏଭିଡେନ୍ସ ଟା ହଉଛି ନା ମୁଁ ଆସେ କେବଳ ମାସକୁ ଥରେ ଇଏ କରି ପଳେଇ
That is enough. Even for a month. କେତେ କେତେବେଳେ ଆସିବ?
PW5 ସେ ୱିଟନେସ୍ ଟା କେତେ?
PW5 madam.
PW5
କୋଉଟା?
PW6 ନା ସେ ଯୋଉ
ନାଇଁ ବହୁଟା।
ନାଇଁ ତା ବହୁତ
हाँ, this is Kunu 5. This is my
Five.
father-in-law.
हाँ
My husband had seven placed with one son and one daughter. I'm getting widow pension from the 4C Gram Panchayat office. I used to stay at Halpur and come to Chhatrapati once in a month. Yes. I used to stay in the house of the accused when I come to Chhatrapati. So this is also nullified that way.
Paragraph 4 down. After the death of my husband, I stayed in my paternal house for about 5 years. କେବଳ ପେନସନ ନିଏ ନବା ପାଇଁ ଆସେ ବୋଲି ପେନସନ ନବା ପାଇଁ ଆସେ
ଆସିକିରି ଏଇଠି ଯୋଉ ରହେ probably that is the father-in-law who has opposed or might have criticized. So
because one
that is
another
not
witness
his
my lord,
person.
that is PW
So
10 my lord.
because it touches his conduct
We
and
don't-
character,
my lord, PW 10 my lord.
might have enraged him. as
PW
a
10
son.
para 1.
Huh?
PW 10.
Huh.
He has given evidence that the accuser was having relations with my
ସେଟା
sister.
ତ substantiated one.
ତାପରେ ବାହାରିଲା
ସେଟା ବାହାର-
କହିକି
They have not stated it.
first time
First time
not before the police. ଯୋଉ ମାସକୁ ଥରେ ଆସେ ମାନେ ଯାଏ କୋଉଠିକି ନା ଚିତ୍ରପୋଷୀ ପଞ୍ଚାୟତ ଅଫିସ ଯୋଉ ପେନସନ ପାଇବା ପାଇଁ ସେତିକି ବେଳେ ମୁଁ ଆକ୍ୟୁଜଡ ଘରେ ରହେ ଅଦରୱାଇଜ ମୁଁ ସବୁବେଳେ
Maternal.
ମୋ ବାପାଙ୍କ ଘରେ ପାଟର୍ନାଲ ମୋର ବାପାଙ୍କ ଘରେ ରହେ ପାଟର୍ନାଲ ହାଉସରେ 5 ବର୍ଷ ହେଲାଣି ମୁଁ ସେ ଆଏ and these accused also having his wife and sons.
PW4
आर भी वाइफ एंड सन्स ଅଛନ୍ତି ସେ ଯୋଉ ତାର ନିଜର ଇଏ ଅଛନ୍ତି ପିଲା ସେଟା ଆସିଛି ଏଭିଡେନ୍ସ ଅଫ
PW4
PW4 para 3 last
para 3 last line.
2 lines. The accused has 3 sons and his wife is also alive. ତେଣୁ ଇଏ ଦିଅର ହବ ତାର ନିଜର ସ୍ତ୍ରୀ ଅଛି ପିଲା 3ଟା ଅଛନ୍ତି ତା ଘରେ ଆସିକିନି ଯେତେବେଳେ ଇଏ ନବାକୁ ଆସେ ପେନସନ ନବାକୁ ଆସେ ସେତିକି ବେଳେ ରହିଥାଏ ମେ ବି ସେଥିପାଇଁ ହୁଏତ ଏମାନେ ତାକୁ ସନ୍ଦେହ କରୁଛନ୍ତି ଏବଂ ସେ ସନ୍ଦେହ ଇଏ କରି ତାକୁ ଯୋଉ ଆସ୍ପର୍ସନ ଆସିଛି ସେ ଏଭିଡେନ୍ସ ଯୋଉ ଆସୁଛି There is also no such statement by the doctor who conducted postmortem examinations that it is sufficient in ordinary course of nature to cause death. It's only stated that it is cause of death was due to this. Thirdly, if it is done with the intention of causing such bodily injury to any person and the bodily injury intended to be inflicted is sufficient in ordinary course of life. That is one of the four clauses.
Clauses in the
So, Mr. Das,
Madam.
we have already kept this matter to 9th July.
It is sudden single blow my lord joda chode. That is in Kasi Prasad in 2008 matter.
No, single blow semti kichi nahi. Single blow
the
dele
single-
302 habani
Habani.
boli semti kichi. That's not.
That
It depends upon
the
କୋଉ ଜାଗାରେ ମାରୁଛନ୍ତି ଆପଣ କୋଉ ଫୋର୍ସ ରେ ମାରୁଛନ୍ତି କୋଉ ୱେପନ ରେ ମାରିଛନ୍ତି ଆଉ ବାକି ବ୍ୟାକଗ୍ରାଉଣ୍ଡ ଅଛି ନା ନାଇଁ ପ୍ରୋଭୋକେସନ ତେଣୁ ସିଙ୍ଗଲ ବ୍ଲୋ ଦ୍ୟାଟ୍ସ
ସେଟା ଆକ୍ଚୁଆଲି ଏକ୍ସପ୍ରେସନ
ତେଣୁ କିଛି ପ୍ରୋଭୋକେସନ ନଥିବ ଆପଣ ମନେକର ଚେଷ୍ଟ ରେ ଗୋଟେ ଡିପ୍ ପେନିଟ୍ରେସନ ଆପଣ ପଙ୍କ୍ଚର୍ଡ ଉଣ୍ଡ କରିବେ କୌଣସି ସାର୍ପ କଟିଂ ୱେପନ ଲାଇକ ନାଇଫ ଗୁପ୍ତି ଟାଇପ ର and that is got and
where the assault was
ତେଣୁ yes single blow ହେଇଥିବ କିନ୍ତୁ background ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଥିବ
ତାକୁ all the
grave and sudden provocation quarrel ହେଇଥିବ so that's a different matter in single blow ର ସେଇ ଯୋଉ ଇଏଟା that has long since been stated that there is no such part of the body selected is very vital also.
Exactly. That is the
Right.
most.
କାରଣ ସେକେଣ୍ଡ ଯୋଉ ସେକେଣ୍ଡଲିଟା ରହିଛି ନା secondly 300 second clause secondly ରହୁଛି ଯେ if you knew ସେ ଯୋଉ
That is
knew that somebody you see if somebody's hands is cut whether can somebody expect or that the death would be so again it depends upon that ତେଣୁ ତମର ତମେ intention ନ ଇଏ ଥିଲେ ବି ଯଦି knowledge ଥିବ ଯେ ତମେ ଏମିତିଆ ଇଏ କରିଛ ଯୋଉଥିରେ likely ତାହେଲେ ମଧ୍ୟ ଆସିବ ସେ ତା ଭିତରେ if ଏ ଯୋଉ knowledge କଥାଟା କହୁଛି if the person committing the act knew that it is imminently dangerous, that in all that it must in all probability cause the death, or such bodily injuries are likely to cause death, and commits the act. So সেটা মধ্যে plus 4 clear রয়েছে। So intention cover করছি তিনটা, firstly, secondly, thirdly, knowledge cover করছি fourthly। এই যে তিনটা কভার করছি ফার্স্টলি সেকেন্ডলি তাদের ତେଣୁ ଫୋର୍ଥଲିଟା ଆସିଲା ମାନେ ଇମିଡିଏଟଲି ଆପଣ ପାର୍ଟ 2 କୁ ପଳେଇବ 304 ପାର୍ଟ 2। ଆଉ ଏଇ ଯୋଉ 1 2 3 ଭିତରେ ଯଦି ଆପଣ ରଖିଦେଲେ ତାହେଲେ ଏକ୍ସେପସନ ଭିତରେ ଯୋଉ ଏକ୍ସେପସନ୍ସ ଗୁଡାକ ପ୍ରୋଭାଇଡ କରିଛି ତାହେଲେ ଆପଣଙ୍କର ସେଠିକି ଯିବ ପାର୍ଟ 1 କୁ ଯିବ। So get prepared. Yes, any other questions?
Serial number 46.
You have prepared the written note of argument.
No, he admitted to have committed the offense. He admitted to have committed the offense. And also admitted the presence of the eyewitness when the occurrence took place.
No, admitted. In court, he has confessed his guilt.
Yes, during recording of his 313 statement,
Okay.
he admitted that he committed the offense and also admitted that the witness was the son witnessed the occurrence and no defense plea was set up.
In any case, whole case has to be seen because it
Yes.
is grave. Despite the fact that defense plea he has admitted, we have to take the whole thing.
So the eyewitness is there.
Yes, his son of the appellant is an eye.
କାହାକୁ ମାରିଛି?
Mark.
Oh, I see.
In presence of
In the child.
Decapitated the
Okay. The age of that child?
13 years.
13 years.
decapitation.
Yes.
Special Judge Bhubaneswar matter appeared.
Oh, sit asile. Pick part gale Mr. Mishra. कितना नंबर आइटम? कितना नंबर आइटम?
Item supplementary one.
Supplementary what order टाटी के बात पहले.
ये जो SN में स्वयं देखते हो थोड़ा पहुंचे से पहले जो I'm not accepted.
One council states that institution the appellant appeared through virtual mode from special jail and submitted that earlier engaged Mr. Lingaraj Mahanti as his advocate, but since the said council did not respond to him, he wanted to change his advocate. He further submitted that he is not having any acquaintance with Mr. S.N. Mishra 4, who is present, and seeks 1 week time to apprise this court as to whom he wanted.
अच्छा ठीक है
सोमनाथ
जी
କାହାକୁ ଓକିଲ ଭାବରେ ଦବାକୁ ଚାହୁଁଛ ନା ଜାଣିପାରିଲ
ହଁ
କାହାକୁ ଦବ
ସରୋଜ ମିଶ୍ର ନା କଣ ତା ନାଟା ଭୁଲୁଛି
ସତ୍ୟନାରାୟଣ ମିଶ୍ର ଆମେ କହୁଥିଲୁ
ହଁ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ତାକୁ ଦେଇଛି
ତାଙ୍କୁ ସେ ଅଛନ୍ତି ଏଇଠି ଛିଡା ହେଇଛନ୍ତି ଦେଖନ୍ତୁ ଛିଡା ହେଇଛନ୍ତି ସେ ସତ୍ୟନାରାୟଣ ମିଶ୍ର ଛିଡା ହେଇଛନ୍ତି ତାଙ୍କୁ ଆମେ ଦେବାକୁ ଚାହୁଁଥିଲୁ ଆପଣ ଗତ ଥର କହିଲେ ଯେ ମୁଁ ଆଉ ଥରେ ଦେଖିକିରି କହିବି ମତେ ଚିନ୍ତା କରି ଆଜି ତାଙ୍କୁ ଦେବା ତ
ହଁ ଦେବା
ଠିକ ଅଛି ଠିକ ଅଛି
ଦେଖନ୍ତୁ
Mr. Mishra, now you cannot say that I am not acquainted. You are acquainted, he is also acquainted.
As per the order dated 26/6/2024, Somnath alias appellant Somnath alias Bhanjya Purti appeared through virtual mode from special jail Bhubaneswar and
Confirm.
confirm that he wanted to engage Mr. Satyanaran Mishra IV as his counsel. Since you have already filed your Vinama,
Yes, nothing.
not filed. So, Mr. You just collect one Vinama is there. We can. Mr. Accordingly, Mr. Satyanaran Mishra IV is engaged as the counsel for the appellant, and counsel for the state shall obtain Vinama of the appellant. Put up this matter. ଆପଣ paper book collect କରିଦେଲେଣି?
ନାଇଁ କିଛି
Paper book ହେଇଯାଇଛି ତ? ଦେଖିଲେ? Huh? Let a copy of the paper book be handed over to the Mr. Mishra in course of the day. The name of other counsel shall not be reflected in the cause list. Hala? So we'll keep this matter next week, get prepared. Put up this matter on we commencing from 9th July 2020. And येटा receipt टा करने ही, है ना? Mr. Tripathi,
Yes, ma'am.
ଗୋଟେ fee नामा collect
हाँ।
करदियन.
ଝାରପଡ଼ା ଜେଲ୍
ଏଠି ଅଛନ୍ତି
ହଁ
ତ?
ଝାରପଡ଼ା
ସ୍ପେଶାଲ ଜେଲ୍ ଲେଖା ହେଇଛି
ସ୍ପେଶାଲ ଜେଲ୍
ଝାରପଡ଼ା।
ଭୁବନେଶ୍ୱର।
ହଁ।
Reference.